Have a seat.
I'm not.
Have a seat.
Your Honor, I haven't had.
Have a seat. Did you understand what I just said?
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here.
So you're saying that I have to say the words "I understand"?
Sir, I'm not saying that you have to say anything. You can play games with me all day. I got all day. I got all day. Have a seat. Do not interrupt me.
I can object to
Do
that.
not interrupt. Do not. One more time. You're going. In this matter, sir.
Yes, sir.
I do have to advise you that in this case, you are charged with the offense of assaulting, resisting, or obstructing a police officer. That is a high court misdemeanor felony, punishable by up to 2 years and or $2,000 fine plus court costs. You understand that?
I understand your charge.
You understand also that there is great peril.
Buckle up, guys. Today we are going to witness a courtroom moment that turns tense almost instantly. The judge quickly shuts down the defendant's attitude, making it clear that respect is non-negotiable. As the case is formally called, the defendant tries to justify incomplete work, but the judge's firm tone establishes control. From the very beginning, you can sense this won't be a routine hearing. The authority in the room is undeniable, and even small missteps are corrected immediately. This opening sets the stage for a case driven by accountability and consequences. The defendant's tone already puts her at a disadvantage. The judge is watching closely, and nothing is being overlooked.
One representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said? That there is great peril in representing oneself.
I comprehend what you're saying, Your Honor.
Hey, what? Either you're going to answer my questions and you're going to answer them properly, or we're going to have a long time and I'm not going to have these people wait. So while you decide how you're going to handle this, I'm going to have you have a seat. I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat. And you might want to wipe that smirk off your face while you're doing it. State your name.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant.
The defense begins outlining the situation, but it quickly becomes clear that the defendant has missed key requirements. Alcohol screening was not completed, and a scheduled test was missed, raising immediate concern. The defense attempts to soften the situation by mentioning employment and requesting more time. However, these explanations feel more like damage control than solid reasoning. The judge listens carefully, but the repeated lack of compliance starts to weigh heavily. This moment builds quiet tension as the court begins to question reliability. Each misstep adds pressure. The situation slowly shifts from explanation to accountability.
Representing himself, I apprised him of the maximum penalties and the charges. Apprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges, which include allegations of
Not my question. You understand that there can be serious peril in representing yourself.
I recognize what you're saying, and I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, then stop there.
Yeah.
You recognize that.
Recognize.
Do you understand that I would?
Probation steps in with detailed records, adding more pressure to the situation. While there are no direct violations on monitoring, the lack of consistent reporting stands out. The defendant hasn't checked in for weeks, despite clear instructions from the court. This shifts the narrative from a single oversight to a pattern of neglect. The judge now has documented reasons to doubt compliance. Each detail reinforces the idea that opportunities were given but not taken seriously. The evidence speaks louder than excuses. The courtroom tone becomes more serious with every detail shared.
That in any of the proceedings that the court would hold you to the same standards as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself. You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be,
Your Honor,
you have a seat.
I'm not,
Have a seat.
Your Honor, I haven't had.
Have a seat. You can play games with me all day. I got all day.
The judge takes control and begins direct questioning, shifting the tone to confrontation. The defendant struggles to provide convincing answers, often falling back on forgetfulness. The judge reminds her that she had already been given a second chance earlier. This exchange highlights a growing frustration in the courtroom. The more the defendant speaks, the more it becomes clear that responsibility was not taken seriously. The tension becomes sharper, and the judge's patience continues to wear thin. Every pause works against her. The pressure now feels unavoidable.
I got all day. Have a seat. The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5 to 10 minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
Good afternoon, Your Honor. Daniel Magoo. Here in Dewey Juris.
All right. So on this matter, I was apprising you of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril in representing.
Listening, sorry.
The court now moves into a serious warning phase, where consequences are explained in detail. The judge mentions a possibility of maximum sentencing, signaling how serious the situation has become. The defendant appears confused about basic requirements, which only adds to the concern. The judge carefully explains what should have been done, making it clear there are no excuses left. This moment builds heavy suspense, as it feels like the final warning before a decision is made. The tone is no longer advisory. It is firm and final. The courtroom feels on edge.
My notes, I apologize, Your Honor. I meant no disrespect.
The court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims.
The judge reaches a breaking point and delivers a firm decision. With limited options left, a 3-day jail remand is ordered for the violation. The shift from discussion to punishment happens instantly, leaving little room for argument. Court staff begin the process of taking the defendant into custody. This moment hits hard, as the consequences of repeated non-compliance finally catch up. The courtroom atmosphere changes completely, turning from dialogue into enforcement. There is no negotiation left. The reality of the situation becomes undeniable.
That I violated any kind of anything that day. So I'm here waiting for that to occur. So no, I don't understand.
Waiting for what to occur?
Well, under the rights to due process, Your Honor, 4th, 5th, 8th Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son. And I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not, is not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still
I
waiting.
wish you wouldn't. I just need to understand why you don't understand.
I'm trying to get there, Your
charges.
Honor, if we could talk
I'm
about it.
not asking you whether or not you agree that you should be charged. I'm not asking whether or not you
You're asking-
believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legal?
At this critical moment, the defendant's father steps forward, bringing an emotional element into the courtroom. He speaks on her behalf, asking for leniency and explaining her situation. The judge listens but maintains authority, balancing empathy with accountability. The discussion shifts toward responsibility, payments, and what needs to be done moving forward. This interaction adds depth to the case, showing the human side behind the legal process while keeping the stakes high. His words introduce hope, but the outcome is still uncertain.
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a
I'm
game.
not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m.
Your Honor.
or I will. Do not interrupt me.
I can object to
Do
that date.
not interrupt. Do not. One more time. You're going. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor.
leave now.
I have constitutional.
You may leave
violations.
now.
Let's go. Let's do it.
I have a right to
You
a
may
counsel.
leave.
Do I not have a right to a counsel?
You want an attorney, you may get on an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney,
Your Honor, I have constitutional violations
do
that
you
need
wish to be represented by an attorney,
to
sir?
take an oath to defend the Constitution of the United States of
Then
America.
if you do not want to answer my question, Mr. Allen, he is to be removed from my courtroom.
The defendant is brought back for one final exchange, where the judge makes it clear that her father's intervention changed everything. She is questioned again and admits her mistakes, acknowledging she should have acted sooner. The judge discusses her future, including education and work, while reinforcing strict expectations. The jail decision is ultimately withdrawn and replaced with a final warning. This ending reflects a last chance scenario where the next mistake could have serious consequences. The judge closes with authority and clarity. Everything now depends on her next move. Thanks for watching. Make sure to like the video and subscribe to the channel, and we'll see you in the next video.